Still watching reaction to the breaking news on your screen there. Timothy Omotosho and his two co-accused acquitted of all charges, and that includes human trafficking, rape and racketeering. And of course, this is coming off the back of another story that's been making headlines for the past couple of days. It had been reported that a man who is the principal at Bergview College, that's the school where a 7-year-old girl was raped in Matatiele, has refused allegedly to have his DNA samples taken as part of ongoing investigations. As such, it's still not clear whether or not he's a person of interest or a suspect in this matter. So let's discuss the legalities of having one's DNA extracted and also under what conditions or grounds this could be done. We'll make sense of that as we also take in, of course, the breaking news on your screen. And for all of that, let's bring in attorney Ulrich Roux, who joins us now via our video link. Ulrich, lovely to see you. Thanks very much indeed for making time. And I hope this is not an ambush as I begin with the breaking news just from a few moments ago. Timothy Omotosho acquitted of all charges against him. And it seems for Judge Irma Skuman, this came down to the cross-examination of the accused, placing a particular emphasis on the burden of proof being on the state and not necessarily on these three individuals to prove their innocence.
Yes, certainly. The judge made it very clear that the cross-examination of the accused was of a very poor quality, that their versions were not tested whatsoever, and that the suspect or the victim's versions were not properly put to the accused in order for them to answer adequately to those versions. Now, the purpose of cross-examination is, of course, to determine whether a witness, and in this instance, an accused, is telling the truth or not. And your cross-examination must be focused on extracting the truth. And if a person is indeed testifying in a dishonest manner, to show that to the court and to catch them out in their dishonesty. The judge was very scathing towards the state prosecutor, accusing him of not having cross-examined properly and not having done his job properly. So certainly an interesting judgment today, but for all intents and purposes, it seems as if the right judgment has been handed down, given that the accused person's version was not tested properly, and accordingly their version must be accepted.
This is scathing, of course, on the state itself. And I imagine, Ulrich, of course, we can't predict what happens next, but it may very well be grounds for an appeal.
Well, the state can only appeal on what is contained on the record of the proceedings. So those questions that were put to the accused during cross-examination, they cannot repeat that. They are confined to what is contained on the record, and accordingly, I don't think that there would be much chance of a successful appeal being launched by the state. Remember that any accused person before court is presumed to be innocent until proven guilty, and a critical aspect of the state attempting to prove this guilt, should they have sufficient evidence, is showing that the accused person is not testifying honestly, and that they are trying to mislead the court. And certainly the state was not successful in doing that in this matter. So I do not foresee them being successful on an appeal, to be honest.
Yeah, not to pull you into the realm of just general commentary, but I also imagine what this particular outcome will bring into sharp focus, that ongoing debate around whether or not someone being proven not guilty necessarily means they haven't committed a crime. Given just how many people had come out and what was said from those testimonies, something like that certainly can't be ruled out, the debate at least in the public domain.
Yes, certainly, and this will continue to be a debate for many years to come. Remember that in order for a person to be convicted of a crime, so found guilty of a crime, their guilt must be proven beyond a reasonable doubt. Whereas if the court finds the accused person's version to be reasonably and possibly true, then the court must acquit that person and find them not guilty. So those are the rules that are applicable in a criminal matter. And at the end of the day, the state, the onus is on the state to prove the evidence in their possession beyond a reasonable doubt, and that's what it always comes down to. There's the old saying that it's worse for a person who is not guilty to be found guilty of an offence than it is for a person who's guilty to be found not guilty. That is obviously open for public debate, but at the end of the day, it all comes down to what the state is able to prove and the evidence in their possession.
Sure. So much to glean from this particular case. But the other story we were hoping to get your legal insight on, of course, is around the rape of a 7-year-old girl in Matatiele. So much being said about the circumstances surrounding that particular incident, but it's also really brought into sharp focus debate around the principal who is said to have refused to have his DNA samples taken. What does the law prescribe about whether or not somebody would be compelled to comply with a process like that? I mean, what steps, for example, would the investigating officer have to take for someone in that position to be forced to give of their samples?
Well, certainly the principal of the school and the other persons of interest have rights, and they are entitled to the protection of those rights in terms of the Constitution. But in a matter such as this, if they are a potential suspect and they are a person of interest, the police in this matter have identified 3 persons of interest within the school, then it would certainly be in their interest to cooperate with the police investigation. If they have nothing to hide, and if they have done nothing wrong, then there should be nothing preventing them from doing so. So certainly it is circumspect that the principal initially refused to provide his DNA sample. The reports that I've read are that he has now indeed furnished the police with his DNA sample. But a person cannot be forced as such, if they are not a person of interest, to provide the police with their DNA. The options available to the police then are, if they have sufficient evidence which implicates such a person of interest, is to arrest that person, and once they have been arrested, then they are compelled to provide their DNA sample to the police, as this forms part of the investigation, and they are obviously under arrest. There can be no instance where a person, when they are arrested in a matter, can refuse to provide their DNA sample. But certainly, this has raised questions as to whether indeed this principal has been involved in this horrific matter, given his refusal to provide his sample initially. And one would now have to wait and see, what his DNA sample presents, and whether there is indeed a link between his DNA sample and the DNA found on the victim, which would obviously implicate in the committing of this crime.
Absolutely. Is there a clear standard, Ulrich, of what needs to be considered before a person can be legitimately considered a person of interest? In other words, I don't imagine investigating officers can arbitrarily, rope people in crimes under the auspices or under the grounds of being considered persons of interest. Or perhaps I should phrase my question differently. In this particular case, my understanding is that the principal is claiming that he wasn't even at the school at the time of the rape itself. And I suppose it's on those grounds that he would have pushed back against this if in fact he was identified as a person of interest.
Well, certainly it all comes down to, once again, to evidence in possession of the police. So they cannot just go up to any person on the street and demand a DNA sample, for example. But if they have evidence which links the principal to this matter, then certainly they will be within their rights to have an interview with this person, to explain to him, the evidence linking him to the crime, and then to explain to him the implications of him refusing to cooperate with the police and refusing to provide his DNA sample. Now, the investigating officers in this matter must, for some reason, have evidence in their possession which leads them to believe that the principal was involved in this matter. They would not just go up to him out of the blue and demand his DNA sample. So again, it comes down to evidence. It comes down to whether a person can really be regarded as a person of interest. His version will be tested. But at the end of the day, this will all be taken into consideration when determining whether he was involved or not. Was he cooperative with the police? Did he, answer any questions put to him truthfully? Does he seem to be a person who is evading certain questions put to him, etc.? And this will all be canvassed in court and ventilated in court in order for an objective decision to be made by a presiding officer who presides over the matter at the end of the day.
To what extent can somebody, generally speaking, Ulrich, refer to things like religion and culture as a reason for not cooperating with any of the expectations from investigators? I know, for example, there are religions where you can't draw blood for whatever reason. Would that stand?
Yes, this certainly is a grey area or an area of contention, and in terms of our constitution, every person has the right to freedom of religion and to exercise their religious beliefs. In this instance, if a person claims that they refuse to provide their DNA to the police in a valid investigation, then it would be up to the state to approach the High Court of South Africa in order for an order to be made which forces this person to provide their DNA, given that in this instance the victim in the matter is a minor child and the High Court is the upper guardian of all minor children in South Africa. So it becomes quite a legal argument. Your right to freedom of religion and to freedom of your religious beliefs cannot trump the right of the police to conduct their investigation thoroughly and for the South African criminal justice system to protect victims of crime. In this instance, of course, very tragic that the allegations are that a 7-year-old girl was raped at her school. And certainly the right of that victim should take precedence over a person exercising their right to freedom of their religion. But that would be a case that would be ventilated in a high court, and for a high court judge to weigh up these rights and to determine whether the right of the police to obtain the DNA sample trumps that person's right to religion or freedom.
Loud and clear. Ulrich Roux, always appreciate your making time to help us understand these sometimes complex legal matters.